Good morning. Please be seated. This is the time and date set for oral argument in cause number CV18-0407, Troy Haberl versus Michael McAllister. These proceedings are being video and audio recorded as well as being live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve any portion of the time you will need for rebuttal, if you desire. Also, we have read the briefs, we have conferenced this case, and we are familiar with the facts, so use that as you will. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
Hello, I'm Daryl Manhart. I represent plaintiffs Haberl. They are in the courtroom today, as well as my co-counsel, Jay Curtis. And I'd like to reserve at least 5 minutes of my time. There may be some cross issues I'll have to address. This is a case where it's a lawyer malpractice case, really, but we're talking about the underlying case, which was a tort case brought by the defendant lawyers on behalf of my clients, Haberl. Our position is that malpractice occurred when those defendant lawyers failed to name Lamar's Truck and Trailer as a defendant, LMTT, and in the case here now, they filed a motion saying there was no duty owed by LMTT to plaintiffs Haberl, and the trial court granted that motion. Summary judgment was granted only on duty, so that should be the only issue that's addressed in the appeal. Now, the principal case to rely upon here, I think, is the Supreme Court's decision in Quiros. Quiros talks about two sources of duty. I guess I should state it follows up on Gibson in both cases, stating that foreseeability is not the basis for duty. Both of those cases state that duty arises from relationships, special relationships that might be common law ones, things recognized in the restatement, or special relationships that arise from some public policy for which generally statutes or regulations are the source.
Or by agreement.
Pardon?
Or by agreement of the parties.
Yes, Your Honors. The special relationships can include contracts, family relationships, undertakings. And an undertaking frequently is a form of contract, so there's some overlap in talking about those two. And in this particular case, we're talking about a contractual undertaking, a contract that LMTT provided services to the tractor trucks that Mr. Haberl and his company used, that they owned and he drove. And they also, that constitutes an undertaking when they actually provide those services, whether there was an actual contract for them or not.
Let's talk. Go ahead, sorry.
Describe the main points of the agreement. Whatever you want to call it, a maintenance agreement?
Sure.
It's verbal, correct?
That's correct. There's no written agreement. There's a regular relationship that Haberl basically has his trucks based there, and his biggest contracts are with a related company there on that same campus. So he has a lot, not all, but a lot of his service done there because it's convenient. He takes advantage of their arrangements with a local tire service provider too. So he has regular maintenance there, not limited to tire maintenance, but including tire maintenance. And I think it's covered in the brief. One of the things that gets done is tires get taken off and put on or shifted around to maintain sort of similarity of treads on all these tires. So there's a regular relationship with LMTT and Mr. Haberl's company, and he has his tire maintenance done there. And in fact, they let him keep a store of his tires there. It's referred to in the brief also as runouts, which are
Okay, without
Yes.
a written contract, how are we to determine the scope of the responsibility, or as you put it, special relationship between the two? When it comes to the tires, what is required by this oral agreement?
Well, Your Honor, I don't think you have to have that. I think that if you're looking at applying Diaz, that there was, I guess, a contract of whatever was signed by the person to have the oil change done, but you don't have to have that. And if I could point to even the undertaking language quoted or stated in Kiros that I'd like to quote, it's paragraph 66 primarily, but paragraphs 14 and 66 both refer to undertakings in the restatement. And paragraph 66 in particular says, quote, a duty based on a negligent undertaking exists when a person who otherwise owed no duty to plaintiff voluntarily agrees to provide services for another person. Under such circumstances, the person assumes a duty to exercise reasonable care in providing those services. That's the end of the quote. So whether you have a written contract or not, if you're providing services, once you start providing those services, there's a duty. And in this case, that's the end of this appeal. The establishment of the duty means this case is over, in that the lower court was incorrect. The lower court found there was no duty. Everything else talking about, well, what did LMT have to do or not do, that's standard of care. Both Kiros and Gibson quote Prosser on that. What a defendant must do or must not do is standard of care. So all you're talking about here is duty.
But it seems like a fine line that you're trying to draw there. Let's go to the language in Diaz. The court says, similarly, the scope of Jiffy Lube's contractual undertaking significantly influences the determination of whether duty exists to inspect the tire. So don't we have to nail down fairly tightly the scope of the contractual undertaking here?
I don't think so, Your Honor, but to follow up, I think on
let's try.
On Judge Campbell's question too, while it's not something written by plaintiff, it's the self-created record of LMTT. Their own work order says that they are supposed to remove the tire in the LRI position and replace it with a good runout. So there's something in their own writing they've created that they understood that their undertaking was to remove the tire in the LRI position off the drive axle and replace it with a good runout. Now, whether they did that or not is, again, breach, standard of care, causation issues. It's not duty. That establishes the duty. They took off the tire in the LRI position, one that was actually a fairly recently purchased tire. It was simply that he wanted to have that saved because of the tread on it, and they were supposed to put on a good runout. They put on a tire that exploded shortly thereafter, and that's what caused the injuries. So you have something that's focused on the very same tire position. And while they're not Arizona cases, I did cite several, I'll say a few, there's maybe 3 other cases where you had other jurisdictions recognizing that when you're hired to provide service at that particular location and something bad happens later, there was a duty. You can argue about whether there was breach and causation issues, but duty's established. And that's what I'm saying here, that I think this case is really that simple. LMT was hired. Their undertaking was to remove the tire in the LRI drive axle position, replace it with a good runout. They undertook to provide that service. That's the duty. Afterwards, that's the tire that exploded. Now we can talk about whether there was breach or not. But
Does the fact that your client is the one that supplied the tires for replacement have anything to do with the duty?
No. I know that that's what defendants want to argue, but to take look at the other cases, including Diaz, even though I acknowledge they found no duty there, nobody's arguing that because the spare tire is owned by the person, that the decision that it's a suitable spare to put on eliminates duty.
And unlike Jiffy Lube, etc., you're talking about your client is a sophisticated consumer of trucking services. Would you agree?
Well, Your Honor, he's not a mechanic. So yes, he's a sophisticated consumer in that he knows a lot more about trucks than I do, and I presume any of you. But that doesn't mean that he's sophisticated with tire standards. And certainly if you again look at the record and the testimony of mechanic Frakes, removing truck tires is not as simple as me jacking up my car and putting on a spare when I get a flat. They require special training and special tools. It's a dangerous activity.
But aside from that, let's talk about the storage of the tires. If it was, as your expert opined, the age of the tire that caused it to blow out, and if we understand that your client is the one that's storing these tires, whose responsibility was it to check the age of the tire?
Well, Your Honor, that was LMTT's responsibility. First of all, because they're that's the mechanic, and he's the one that's putting it on, that's his responsibility. And while you said it's our expert, it's actually also the clients of my adversaries here, when they were counseled for my client, their own testimony or their own position was the age of the tire alone makes it unsafe. As far as the storage, though, the record is that while he had tires there, he wasn't allowed to go up there.
And I get all of that, but as a business owner, we keep invoices. Bought this tire this time, this tire this time, have this one up in storage. Was anybody keeping track of the tires that were being stored by LMTT?
No, Your Honor.
For your client?
No, neither LMTT nor my client kept that record. But also there's substantial evidence here that the particular tire we're talking about was not one owned by my client. And I hope I've covered that adequately in the brief. I can recite those things here for you to do, but there's a number of factual disputes that go to whether that tire was owned by my client, and that's another error the trial court made in just accepting the statement of the defendants that it was necessarily owned by my client. So, but even if it was, and part of my point too is that it's not plausible that the way tires wear out, that he would have an 8-year-old tire, but even if it was, the only person who was up there inspecting it, who selected it, was LMT's mechanic. And once he put it on, because these are the paired tires, the serial number that would let you identify the age of the tire, assuming you knew that that was how you could do it, is facing the other tire, so you can't see it anymore. So Mechanic Frakes was the only person who was in a position to determine that, and he didn't. And that's, I think we're going to now to breach and negligence again, not duty. Duty was when they undertook to provide that service of removing the one tire and replacing it with another. If you pardon me for belaboring it, I want to repeat that last part of the quote I read from paragraph 66 of Quiros. Under such circumstances, the person assumes a duty to exercise reasonable care in providing those services. Again, that's duty, and that's all we're here to decide today. The rest of this is not about duty. And the arguments that they've put in their answer brief, where they want to talk about DOT regulations and everything else, that's all has to do with standard of care. I want to get also to the fact findings, only to repeat my statement that's in the brief, which is those are erroneous. At least I think it's 4 through 7 we've specifically identified, and why they're erroneous, why they failed to honor the requirement that you construe the facts more favorably to the plaintiff on a summary judgment motion. And the defendants have already shown that they intend to keep trying to rely upon those facts in other issues that are still pending in the court. So while I'm asking here for reversal on the summary judgment, I'm requesting that you specifically state in the decision that you're vacating those fact findings as well. I'd like to reserve the rest of my time. Thank you.
Thank you, counsel.
Good morning. Miles Hassett for the McAllister appellees. We've divided the time the appellees have between myself and Mr. Profit. I'm to take 14 minutes. I'd like to try and honor that. Mr. Profit will have the remaining time. I plan to address the issue of duty. Mr. Profit will address Iowa law issues and, of course, any questions. I'm delighted to hear my opponent mention Quiros, however we might pronounce it. That is, of course, the latest opinion from our Supreme Court on the issue of duty and where duty may be found. Duty is found in the relationship between the parties. That was this court's decision in Diaz. So what is the relationship? Judge Brown, you asked what are the main points of the agreement. Let's give the agreement some context. There is, in fact, contrary to what Mr. Manhart stated, there is, in fact, a written agreement here. It is the lease agreement that Mr. Haberl did business with Schuster and LMTT under for 10 years. And that agreement, he admitted in deposition, governed his relationship with LMTT and with Schuster. It's how he got paid. And in fact, when maintenance was performed on his vehicles, monies due to him under that agreement were charged back by Schuster. So this was the arrangement that they lived under. That arrangement, that contract is pertinent really only to our discussion here in terms of what are the obligations undertaken by the Haberls. And that is...
So, Mr. Hassett, your argument is that LMTT's file note on this incident, where they are acknowledging that their job here is to replace that tire with a good run out, is strictly conditioned and limited by the language in the independent contractor lease agreement, paragraph 5, which means its inspection obligation is limited to compliance with the federal motor carrier safety requirements.
That's part of the equation, Judge Winthrop, and thank you for that question. The agreement, the written agreement, specifies that the Haberls are responsible to maintain their equipment, including tires, in compliance with federal regulations. The specific agreement, the specific undertaking, if you will, to replace this new tire with one of Haberl's runouts or used tires is as follows. A good runout. A good runout is a tire that matches, in terms of its tread depth, the adjacent dual tire where it's going to be matched. So you can't have uneven tread depths. That causes a problem with the vehicle. But undisputed in this record is that the parties also understood a good runout to be a tire that was compliant with federal regulations. There is a specific section in the Code of Federal Regulations cited in our brief that identifies what is a legally compliant tire. That tire must have sufficient tread. It cannot have exposed belts in the sidewall. It must hold air. It has to meet a number of different criteria. None of those criteria include the age of the tire. So there's just an undisputed agreement here that the tire that was being replaced, now it's a new tire that's coming off the vehicle at Mr. Haberl's direction, and one of his used tires, the runout, is being put on. What are, Judge Brown, the terms of that agreement? The agreement is that it's going to be a tire of Mr. Haberl's from the area where he stored the tires. It's going to have matching tread depth, and it's going to comply with federal regulations.
Isn't there a question of fact as to whether it was Mr. Haberl's tire?
I don't believe there is. The trial court went into detail on this, and I'm happy to address why we think there is not a fact question. Just as an example, Mr. Manhart says, well, there's a fact question because it's an 8-year-old tire. It couldn't be in the pile. Well, that fails to account for the fact that the tire could have been old when it was acquired by Mr. Haberl. For all we know, he acquired an 8-year-old tire a month or a week before and had it placed in his tire pile. That has absolutely no significance. There is not.
Don't we have to look at every alleged fact in the light most favorable to Mr. Haberl?
You do. I agree that you do. But if we look at the things that make this indisputably Mr. Haberl's tire, they are numerous.
But when we're talking about the facts that you are about to recite, and we're talking about the facts that your opponent will recite, doesn't that make it a factual issue that cannot be resolved on summary judgment?
Well, just because somebody says it's so doesn't make it so, Judge Campbell. And if you will permit me, though, I think it is instructive to look at those facts which establish indisputably that it was Mr. Haberl's tire. First of all, only Mr. Haberl's tires were stored in this area. He was the only owner-operator allowed by Schuster to place tires there.
Well, he didn't place the tires there. I mean,
Personally, he did not, but he directed that they be placed there. No question about that. That's not disputed.
well, his expectation was his tires would be placed in that area, but he wasn't involved in physically placing them there.
For the purpose of this record, that's true.
Sure. Okay.
He's never charged for this tire, the one that's put on the vehicle. He's never charged for the previous Goodyear tire that was placed on the vehicle several weeks before. Mr. Haberl says, well, I don't use Goodyear tires. Well, here's two. Here's two that you had. So just saying something, Judge Campbell, saying, well, it's not mine, it can't be mine, that's not evidence. That's a statement that simply contradicts what is otherwise undisputed, and that should be rejected. That doesn't create a factual dispute. Just saying it's so, that's not right.
Going back to the question of the scope of the duty, you've posited that it's, in fact, a fairly narrow one. Is it possible that this is actually one of those situations where the duty, instead of being strictly a question of law, is a mixed question of fact and law, such that would allow for an argument that the duty to inspect is broader and includes the issue of the age of the tire?
Well, if this court hadn't decided Diaz, Judge Winthrop, I'd agree with you. But in Diaz, the facts are very instructive. There's an agreement to change the oil, check the tire pressure, and do nothing else. The plaintiff complains that the tire at issue in Diaz was visibly deteriorated to the point where any person working on the vehicle could have observed it and therefore had an obligation to warn the owner. The same situation is really presented here, which is the tire has nothing wrong with it either by regulation, looking at it physically. There is nothing wrong with this tire. Now, to suggest that in addition, we've got other things that are being imposed and written into this agreement, that's not what Diaz teaches. Diaz teaches that the agreement defines the scope of the duty. The agreement defines the scope of the duty. So unless there's an agreement here to check the age of the tire, and there is not, that was never determined and never decided by the parties, unless that agreement exists, then it cannot be fairly said under Diaz that the scope of the duty includes an unwritten, non-negotiated, ununderstood term of the agreement to check the age.
How would you account for what happened in Diaz, correct me if I'm wrong, but it's my understanding the customer could have signed up, paid for the inspection, did not. I mean, we don't have that situation here. I'm not, do we? We don't. I don't think we have a situation where LMTT said, look, we'll check the age of the tire. All you have to do is check this box and we'll bill you $50 for it. That's not what we have at all, correct?
Well, let me answer that by responding to something Judge Campbell said earlier, which is this was Mr. Haberl's tire pile. Who was responsible to maintain and monitor it? The undisputed record is that only Mr. Haberl's tires went into the tire pile, so he has responsibility for those. The record also is that he never sought to reach an agreement with LMTT regarding what was to be done in terms of monitoring the tire pile, especially as to age.
So when we talk about Diaz, we have went in for an oil service, disclaimed the tire checking, tire is the cause of the injury. Here we have tire service is what was bargained for. Tire is what failed. No disclaimer. So isn't the standard of care more what we're dealing with? Is it reasonable not to look at the age of the tire when installing it? Is that reasonable? Is that a breach of duty? Is it a breach of the standard of care? We know that there is a special relationship here. The service was to be provided by LMTT, and Haberl was responsible to provide the materials for that service. But isn't that about the standard of care? Does a typical diesel mechanic check the age of the tire before installing it? It may not be DOT required, but is that something that is industry standard?
Well, that question is really answered in Diaz. Remember, in Diaz, there was testimony from an expert who said industry standard of care for Jiffy Lube would have been to observe that the tire was visibly bad and shouldn't be on the vehicle. This court in Diaz rejected the standard of care as a basis for establishing duty. So your question, Judge Campbell,
Based
comes
on the
from...
disclaimer, and in this circumstance, there may or may not have been any exterior indicators of wear. But we have tire surfaces being contracted for, tire failing. And what is the standard of care in which a diesel mechanic replaces tires? Because it's a specialized kind of thing. I can't replace a diesel on a truck. You need lifts, all of the things that you need, which LMTT has. But is it reasonable not to check the age of the tire, given that it is a specialized kind of tire replacement?
Well, the question, is it reasonable, presumes the existence of a duty to do exactly that.
Okay.
Right? Curaz teaches that you have to start with the duty. You can't work backwards from what happened or things that might have prevented the accident. You have to instead start with that relationship between the parties. And Curaz, which my opponent acknowledges is controlling, says that the duty question is one which is answered not by the idea of duty is everywhere, everybody owes a duty to do everything, but instead has to be confined based upon the relationship of the parties or some public policy informed by statute or regulation to which the court can point. Of course, there's no public policy here. The only thing that they are arguing is that somehow the tire was old to the point where the standard of care would have required that it not be installed. But that's the standard of care question. It misses the point. The focus is on the relationship. The focus is on the agreement. The focus is on the duty that arises from those things. It is not a duty to do everything. It is not a duty to prevent all harm. It is instead a limited duty to replace a new tire with an old tire that is compliant with the federal regulations and which meets the parties' own agreement, their own definition of what a good runout should be. I'll cede my remaining time to Mr. Prophet. Thank you.
Thank you, counsel.
Thank you, Your Honors. My name is Spencer Prophet with Mayor and Gear, and I represent Kevin and Cheryl Chapman, and Rowley Chapman, and Barney in these proceedings. Before I move on to the other issues presented in our briefs, I want to focus on one of the key disagreements between the parties and perhaps address some of the judge's questions that have come before. Now, what the parties seem to disagree on is whether the trial court looked at duty or instead looked at breach. Now, I would posit that there's a relatively easy way to answer that question. The question of duty looks at who. It looks at the relationships between the parties. In terms of a contractual connection, it asks what undertakings the contracting parties agreed to undertake. The question of breach looks at what. What did they do? Whether it met the standard of care, met the duty that was established in the first part of the inquiry, which asks who these parties are. You cannot get to the breach question, what was done here, until we first answer that duty question. Who are these parties? What did they agree to undertake? You'll notice that appellee's briefs don't talk about whether LMTT evaluated the age or whether it appropriately evaluated the age. That's the part of the inquiry that's breach. We're not interested in breach. What we're interested in is whether or not Lamar's Truck and Trailer agreed to evaluate this tire for age or other suitability apart from the requirements under DOT. Now, both Arizona and Iowa courts hold that a duty imposed by contract is circumscribed by that party's agreement. What did the defendant agree to do? Judge Campbell, your questions regarding whether or not this was a written contract is very relevant here. Plaintiff has to put forth some evidence of what defendant agreed to do to determine whether Lamar's Truck and Trailer had a duty to inspect or warn of age. It's that failure that we're talking about here. The plaintiff has not been able to point to any agreement, oral or written, indicating that Lamar's Truck and Trailer agreed to look at this tire, evaluate its age, or whether it was suitable to be placed on this vehicle, and to refuse to install the tire that Mr. Haberl instructed it to install. That's the question before the court, whether there's any indication that Lamar's Truck and Trailer agreed to perform that service. I think Mr. Manhart's focus on paragraph 66 of Carraz is instructive here. He says, he focuses on the statement that when a party voluntarily agrees to provide services for another person, under such circumstances, the person assumes a duty to exercise reasonable care in providing those services. Those services the entity, the defendant, actually agreed to undertake. What are those services here? It was installation of this tire. Plaintiffs don't fault anything with the actual installation of this tire. Plaintiff's only complaint is that Lamar's Truck and Trailer did not look at this tire, evaluate its age, and provide a warning or refuse to install this tire. Nowhere in this record can you find an agreement by Lamar's Truck and Trailer to do what plaintiff complains it did not do. That's the agreement. That's the relationship between the parties. That's whether or not Lamar's Truck and Trailer owed a duty. We're not interested in breach. We're interested in whether Lamar's Truck and Trailer agreed to perform the services that plaintiff now complains they didn't perform. So let's take a look at the agreements that are between the parties. There is, at least in part, a written agreement. The lease agreement at least provides a foundation for this relationship. It was the lease agreement that under which Mr. Haberl obtained the services that he obtained and that set forth the expectations of the parties in obtaining those services. In that agreement, we looked at paragraph 5 earlier, where Troy Haberl agreed to maintain his trucks, including tires, in compliance with the federal standards. Haberl agreed to be responsible for tires, fuel, and other maintenance. Schuster allowed Mr. Haberl, but didn't require him to obtain service here, and that service would be provided under another agreement. We have that here as well.
I have a quick question, and I want to get this out before you run out of time.
Yes, Your
When
Honor.
I'm looking at this invoice of LMTT, and I don't know why I'm struggling to say that, it says, replace with a good run out and mark the tire for, and it says HABENT. What does that mean?
Habent. It was a convention that they used at Lamar's Truck and Trailer to refer to HEI, or Haberl Enterprises. It's short for Haberl Enterprises, Your Honor.
And what does the mark mean? Just put an H on it, or does it entail, took this off on this date, this is what it is, this is what it is?
Nothing like that, Your Honor. The marking was used as convenience. If Lamar's Truck and Trailer took off one of Mr. Haberl's tires and they couldn't put it upstairs right away and there was some risk of confusion with Lamar's Truck and Trailer's tires that were on the ground floor, they would mark it to make sure that someone knew to take it upstairs.
Okay, so it's just basically to identify it as Haberl's, not LMTT, but there's no date, the marking doesn't do anything.
That's
Just
correct.
wanted to make sure.
And that marking is not assumed to be on every one of HEI's tires. It was only put on under select circumstances if there was a risk of confusion and they couldn't get it upstairs right away. There's no indication that this was on even a majority of Mr. Haberl's tires, which gets into the fact issues. Now, I want to talk a little bit before my time runs out about those fact issues. The plaintiff is entitled to all reasonable inferences, but not unreasonable inferences. The courts have indicated that a reasonable inference is only the consequence must follow after the proven facts or is reasonably probable. Here we don't have that. We have a lot of flat assertions that don't necessarily apply and don't indicate the ownership of this tire. And with that, Your Honor, for the remaining issues, the appellees rest on their briefs. Thank you.
Thank you, counsel.
Your Honor, I'm bad at organizing for rebuttal, so I'm probably going to go reverse here through notes. One of the points that was just made, or in response to your question, was about that marking on the tire. They used an indelible marker to mark tires removed and stored for plaintiff with Habent so that they could identify them. And one of my adversaries said, just saying something doesn't make it so, and they're just saying it was only done under circumstances occasionally and while it's downstairs. That was so that upstairs, someone like a mechanic like Frakes, when he could go up there, he could identify a tire that belonged to plaintiff. And the record in this case is that the exploded tire was examined and there was no evidence found of such an indelible marker, which is part of the fact questions that disputes that the tire that they installed even belonged to my client. And to follow up on that too, if we're talking about an undertaking to take off the existing tire in the LRI position and put on a good run out, and a good run out is supposed to mean one of the tires they've stored for my client, then isn't the possibility that the facts suggest here that they installed a tire that didn't even belong to my client a breach of that duty? Again, I'm talking about breach now because that's what, when you start getting into the arguments that the defendants make, you end up leaving duty and going into breach. Sorry, I'm going to jump around, but they also started off with talking about the independent contractor lease agreement. You could say that's a happy coincidence for them here, but it has nothing to do with the duties of LMTT. It is not a party to that agreement. The agreement allows Schuster to back charge through its affiliates expenses that might be owed to them, but LMTT itself is not a party to that, and it's not an advance waiver. It doesn't say, and if one of your affiliates performs services, we waive claims. LMTT had a duty independent of that independent contractor agreement, and it's irrelevant here. Even the reference to paragraph 5, which again, while I've said irrelevant, I'm going to address it here, which talks about meeting DOT standards. That's so that the trucks that Schuster is leasing under its DOT license comply with its license requirements.
Let's pause because I don't want you to run out of time. When we talk about what was contemplated in regard to inspection of tires, wouldn't a typical diesel mechanic use DOT specs to determine what their duty is?
Well, no, Your Honor. I'm not saying that it's not something that may be a factor, but their case is trying to say you can narrow duty down to just looking at those DOT specs. And I cited another case, now I'm forgetting what the name is, Hutto or something in the reply brief, that talks about meeting certain standards isn't saying that's what the standard of care is. You have requirements to meet for one agency, but that doesn't establish that's what the standard of care for safety purposes. And to use an example that my colleague used in the lower court, if they had pulled a tire out to put on a truck and it had the minimum tread depth that DOT says for a tire to operate a truck on the road, and it didn't have a puncture or leak, and it didn't have cracking in the sidewall, they would say we've satisfied the requirement. But what if it had been recalled by the manufacturer? Is it not a breach if they put on a tire that's been recalled by the manufacturer, even though it meets all those minimum requirements under DOT standards? I realize that I just ask it rhetorically, but I hope the answer to that is, yes, that would be a breach. The standard of care isn't established by DOT. Certainly that might be something, if you looked in the industry, what does the industry decide is the standard of care? They might say, well, one thing is, what are the DOT requirements? But you have experts here that talk about age of tires is something that's known in the industry to be a safety problem.
Well, Mr. Manhart,
Yes.
Mr. Hassett tells us that we really shouldn't be analyzing the issue that way. You can't say, well, this is what the standard of care requires, and then work backwards to say, well, that's the duty.
Your Honor, I apologize if it seemed like I'm saying that. What I'm arguing is that the elements that the defendants bring up to try to inject into duty are themselves standard of care. And I'm saying that when you look at those, what they're trying to say is duty is just you had to meet the DOT standards. No, duty is when they undertook to provide services to remove and replace the tire in the LRI position, they had to exercise the ordinary standard of care in performing that task. When they start talking about DOT requirements or anything else, they're the ones going into standard of care, breach, and causation. Duty was established once they undertook to service that tire in that position. That's all you need to get to for duty. Everything else is another issue. So I'm going to address different fact things too, which is not, but they talk about there being 2 Goodyear tires. We've addressed that in the briefs too. Frankly, it looks like with hindsight, one can see here that LMTT probably had a store of Goodyear tires, and my client got 2 of them. The one that exploded in Wyoming that they initially thought was the bad tire that caused them to sue Tire Den, that was a Goodyear tire installed by LMTT. Then after that was replaced in Wyoming with a new tire, that's the one that's been removed here in September by LMTT and replaced with yet another Goodyear tire. My client's testimony was he never bought Goodyear tires. They point to the record where there was one purchase they can show bought with a Goodyear tire. That's explained by Renee Haberl's testimony that when her husband was injured in the hospital and his truck's out there on the road in Fountain Hills, the only person she could get to go out and replace that tire was a Goodyear tire seller. So that's the only record of a Goodyear tire ever being bought by my client, and yet here's 2 Goodyear tires installed by LMTT. Where did those come from? I'm arguing fact questions now, I realize. Those are fact questions, though, because these are the defensive arguments that the defendants are raising. None of these have to do with duty. I'm coming back to paragraph 66 of Key Rose. Undertaking the services, that's all you need to show to establish duty. That happened here. This is not like Diaz. My client hired LMTT to provide service to that particular tire. That's the tire that exploded. That's their job. Again, I'd like you to reverse and remand this with directions to establish that duty does exist for the case within the case and vacate the factual findings. Thank you.
Thank you, counsel. Thank you all for your arguments. We will take this matter under advisement and issue a written ruling in due course. We are adjourned.